Very tricky.
No, that's okay. I'm sure I haven't helped with the stuff that I'm doing, but you can talk now.
Yes, yes. Now works. I'll just find that Dropbox link.
You haven't downloaded the files yet?
Sorry.
You haven't downloaded the files yet?
No, we'll see if that takes any great amount of time. 11 gigabytes. Right.
Yeah. But let's start. I can probably address a couple of other things that I wanted to until it downloads. How long is it saying it will take?
It's waiting to get into the swing of things now, so the time is reducing. At the moment, it's saying 30 minutes. So apologies for that. I didn't realize there'd be that many. I should have grabbed it in advance. But we'll see if it comes down any quicker.
Okay. So I'll quickly
yeah.
address the other couple of things that I wanted to speak with you about, and then if it continues to say 30 minutes, then we can reschedule to later today or tomorrow. So firstly, did you make any progress in terms of getting clarification from the I don't know whether they're, how do you refer to the leadership or whatever of IBAC about the jurisdiction issue that I'd raised?
In progress of raising it, but haven't finalised the conversations yet, so I haven't got confirmation of what the position is at this stage, but in the works.
Okay, all right. Just so you know, I have also independent. I haven't referred to our conversation extensively, but I've just said that I think that the investigation needs to be basically what I said to you, I've said to them as well. I've not referred to our conversation as such, but yeah, I've just left it at that. Now, the other thing is that I wanted to know from you if there were any schemes equivalent to the assistance for victims of crime or other things that IBAC could provide support through?
In terms of
compensation
support or compensation support?
Financial support.
Yeah, okay. We offer our welfare service, but in terms of financial support and compensation, that sort of thing, it's only the Victims of Crime Service, the state Victims of Crime Service.
Okay, so so they normally require some sort of evidential proof from a law enforcement agency about the reporting and investigation of the crime. So normally when one complains to the police provide the necessary documentation to the Victims of Crime Assistance Tribunal.
Right.
That's the main evidence that they rely on. So what can we get from you to make a claim there?
That's a good question. It's not something that I've looked into or had cause to look into previously, because we've obviously got different restrictions in our legislation in terms of that sort of limit you from being able to tell different people about the investigation, and also that limit me in what I can disclose to other agencies. So that is an interesting question. I might have to get some advice and take that one offline. If it's just a reference number, of course,
No, I think what will be required is the details of what crime has been reported and what investigation is being conducted. So basically, I think the complaint that complaints rather that we've made about the aggravated invasion on the 6th of January, and the fact that the IBAC is now investigating it. So basically, the letter that you sent me, the commencement of investigation thing, that coupled with the details of the complaint. So essentially, what they require is a corroborating evidence that we have actually reported the crime, and that the crime is not it's not fabricated for the sake of defrauding the tribunal out of money. So they don't need, I think, proof of the judicially determined culpability of the alleged victims, but what they need is the fact that people have given evidence against the crime. So normally the police would provide copies of the witness statements that the people have given, which I appreciate now, but I'm happy to give it to you. In fact, what I was hoping to do was first run you through the files, and then basically see how we can use the material that's already been done to provide a more concise statement by exhibiting the material that has already been sworn and accepted in court. Do you understand what I'm saying?
I do, but the difficulty for us, Shivesh, is that the IBAC Act creates an offence for disclosing the fact that IBAC has commenced an investigation into your complaint. So that letter confirming the investigation, the way that the Act unfortunately works, I know it can be frustrating in our experience, but the way that the Act works is that to share that information with other people could be an offence. Okay, so firstly, all the information about the investigation is in the public domain because it's been the subject of court orders. The court has referred to every step of the process in published orders. So, for instance... But this investigation's only just started, Shivesh. Yeah, but as it is starting, we're simultaneously suing the IBAC right now in relation to the steps that they took about this investigation. They have, in fact, provided evidence about what steps they were taking in March this year, and since then we have been providing the court with information about what steps the IBAC has been taking. So that's one thing, but then the other thing is Section 184 of the Act, I think, is what you're referring to. Yeah. I think it has an exception for where it needs to be provided to the court or tribunal in relation to things of this sort. One second. Because it would be a strange thing if they haven't accounted for the possibility that people will need to. I get what you're saying. It would seem like a logical gap, but at this point, it wouldn't be appropriate for me to say, "Oh yeah, you can go ahead and do that," when at least by my understanding of legislation, it's not permitted. So, I just can't, in good conscience, say, No, I don't want to. Yeah, I wouldn't put you on the spot anyway, because these things should be looked into. So, how about we, park that one for, I guess, getting some advice. I have gone through the Section 184 of the Act a few times, and basically what it says is that it should not be disclosed unless, so and so and so. And it also, in the unless category, it says that unless, the information is required
to be provided in relation to summons in the proceeding and so on and so forth. So there are it makes explicit.
There are exceptions.
Yeah, it makes.
I can't tell you with confidence that this fits, so I don't want to lead you astray on that.
Yeah, no, that's fine. There's one other exception where it says that except where, in accordance with any other act, that information would be necessary, for instance, for a court process. So I'm going to look at the Victims of Crime Assistance Tribunal Act as well, and see if it requires the disclosure of information, because I think that act would latch on to this one then. But in any event, if the act was not an impediment, you wouldn't have any issue in providing, I guess it would be a slightly modified form of your commencement of investigation that would include the allegation that we've made.
Yeah, I think from my perspective, I would have to deal directly with the Victims of Crime Service as opposed to like giving it to you to provide to them.
Okay, yes. I'm not sure about how that works.
Yeah.
Okay, but yeah, either way, we're fine. We just want the facts to be reported. So, no, that works. Do you have any experience with this, by the way?
Certainly, in referring people to that as the state's service for victims of crime compensation, but having dealt with a disclosure to them or having handled information with them previously, no, not personally.
I'm sure someone at your agency would have had some prior experience, so they would know for sure whether it can be done or not, right?
Yeah, I'll certainly make inquiries, and I understand that possibly if 184 or 184, 185 is a blocker in our act for that, then that seems like a hole in our legislation that should get changed.
I really don't think that, because the act has been around for 13 years at least, I can't see how all these years people would not have been able to get assistance. So I think let's not, I guess, speak in abstract, but if you could get some concrete answer from someone about whether or not the thing stops you.
Yeah, I'll take that away. I'll check that.
Okay. Also, do you know, with the application, is it made by your agency or is it made by us?
My understanding that it was just dealt with by the affected person. I've never had that agency reach out to us or us have to make something on behalf of someone else. My understanding is that it was, based on the member of the public speaking to them, but as I said, it's not something that I've dealt with directly myself. It's more or less merely something I've just been broadly aware of existing.
Okay. The other thing that I want to flag ahead is that if we're going to write to the commissioner imminently about the return of the seized goods. So we've spoken with Sergeant at the Melbourne West Police Station, and this was last month, and they had said that by the legislation or the regulation, they didn't advise specifically what it was that bound the police, but they said they had 28 days to return the goods after the resolution of the matter. Do you know what legislation applies to this?
It would just be a seizure under a Crimes Act for 65 warrant, and that should be the power. I didn't think the legislation provided a timeline. I know it does in other jurisdictions, but I don't. My understanding I wasn't aware of it providing a fixed time for the return of property.
Yeah, because they haven't.
Certainly, IBAC legislation in equivalent legislation. Just as when we no longer need it, we need to give it back. So it doesn't provide, within 45 days or whatever.
Okay. The sergeant indicated that they have 28 days to return it. I'm not sure what he was basing that on, and I couldn't find anything either. But the
only provisions would be around Section 465 of the Crimes Act.
Okay.
That's where the warrant power comes from.
Yeah, no, we've gone through that. We're going to see if there's any regulation around that as well. But basically, they haven't made any contact about the return of goods. So we will need to raise this with the court.
Yeah.
And especially in proceedings where we are required to do something. For instance, there's a proceeding where the corporation, AGL, the logistics business, the entity that ran it, it may be required to file documents, and all its property and documents were seized by the police.
Yeah.
So we will definitely need to refer to the IBAC investigation in that particular matter, and we'll probably refer to the documents already in the public domain through the proceeding. But depending on what the court requires, we may need to possibly summon. Well, at this stage, it's purely hypothetical because we're going to tell the court that the corporation is trying to get the documents back.
Yeah.
But I'm flagging that we may need some clarification for the court in relation to the allegations that we've made and what is being investigated. So it's not simply that it's an uncorroborated assertion that we're making. Does that make sense?
I would just say that if you need it for your procedures, you're welcome to initiate your own proceedings to try to get a hold of it. In particular, to me, you mentioned Ms. Zhu's phone.
Yes, I have given you the proof of that, by the way, in the documents.
And ultimately, when if I'm of the view that I need that for my investigation, I'll get that by my own means.
Yeah, you can subpoena it, I know.
Whether it's at the time it's in your possession or theirs, I'll have my own sort of means to get it.
Can you help us get our goods back, by the way? Is there anything in the IBAC Act that, or, your procedures generally?
No, that wouldn't really be appropriate for us to sort of do. We can get it for our own purposes if we're relevant to our investigation, but I can't sort of retrieve it on your behalf or for your purposes.
Okay.
Yeah. I certainly, we'll get those things, particularly the phone you mentioned. I've turned my mind to that. Get to a point in the investigation where I do want to grab that. At least that's the intention at the moment. If at that time it's in your possession or Victoria Police's possession, I'll make those, pick the right way to get it. But I can't there's nothing for me there's no lever that I can pull to influence Victoria Police to
No.
to you for your purpose.
Yeah, no. Also, I'm not asking for any, consideration other than what is strictly within your line of duty.
Yeah.
So, okay. No, that's okay. Now, one final thing. Do you have any timeline at this stage about, how long you think the investigation will take, or how long different stages of it will take?
I'd say too early to say. My intention was to grab yours and at least Miss Zoo's accounts of what occurred within the next 3 to 4 weeks.
Okay.
And in the meantime, get those documents of you. I'm obviously doing other things to get other documents and start reviewing those. But at this stage, I haven't had much come back to me, so I don't know how big the mountain is, if that makes sense. I don't know how much I have to get through until it starts to come back to me. So at this stage, it's probably too early to make much of a prediction. Do you have any leave or travel coming up where you won't be available?
I will have to visit home. I haven't in several years, and I want to make sure that I'm not impeding or delaying anything. That's one thing, but the other thing is that we also want some closure.
I understand. It's obviously been a long road so far.
And Miss Yu in particular is quite. It's affected her mental health considerably more than mine.
Yeah.
And
does she want to speak to one of our welfare or providers?
I'll advise her that you.
It's like a confidential. It's operated by a third party. It's not related to us. It's a third party psychologist provider, essentially.
Yeah, well,
she's a witness in this matter, then she's entitled to access it.
Yeah, no, sure. She's also a complainant, by the way. I'm not sure.
We use the term witness generally. Like, witness is basically just anyone who's giving us information.
Okay, all right. No, that's fine. I will actually let her know that you've offered, and then she'll get back to you. Okay, so how are you going with the download?
Sorry, 1 second. So I'm just going to have to relocate for that.
No, it's okay.
One second, Smash. I'll just have you on hold. Sorry.
Mm-hmm. What do you need? The cable?
I need the short cable of the two sides or both sides are
This one?
USB, yeah. Is that the Google one that you have?
No, this is one of the.
Yeah. So are you? Okay. By the way, I sent you the Boulton.
Sorry, my apologies for that. I just got kicked out of the room that I was using.
No, that's okay.
You just said something and I just missed it.
I was asking you how you went with the download.
Yes. I think it had 10 minutes to go when I last looked.
Okay. Well, we probably have to reschedule then. Or if it's there, then I can walk you through now. But
Okay, we might have to reschedule for that because it's hit a snag of some description. I think because I'm portable at the moment because I'm moving from room to room.
okay. Yeah, no, it'll probably need you to not disrupt the process while it's.
Yeah, once I'm plugged back into my desk on the hardwired internet, it should download much quicker.
Yes. So when do you want to speak?
I reckon just to make sure that. What does Monday look like for you?
Monday's gonna be tricky. I'm not sure. So we have some court lodgements that we need to physically make on Monday, and there's a couple of other things.
My week is better next week. It's not as bad as it is this week.
Okay,
like
so
Tuesday I've got
you're not available tomorrow?
Say that again?
Do you have time tomorrow?
Tomorrow's not good.
Okay. So
Friday's
Monday.
not good for me, unfortunately.
Okay. If you're flexible on Monday, I could probably find some time.
Yep.
But can you give me a window when you're available?
Middle of the day, 12 till 1:30.
Okay. Anything else?
And the only other one would be early in the morning from 8 till 10:30. Or 8 till 10.
Okay. And what's your availability on Tuesday?
Tuesday between 11 and 1:30 or after 2.
Okay. So
Yeah.
like, can we tentatively say like Monday 12:30, and
Yeah.
if if I can't make it, then we'll speak on Tuesday after 2.
Alright, so I'll just put that in my calendar now, so I've got tentative bookings. I'll go back to my desk and download everything now, and I might just flick you an email to say, yes, it has downloaded successfully, or whatever the case may be.
Yeah.
Hopefully, assuming that's the way that goes.
Okay.
The other 2 takeaways. So I'll come back to you on that question you raised about the investigation commencement basis issue.
The
hopefully
jurisdiction.
over the next few days.
Yes.
I will see if I can shake any information out about supporting a victims of crime service application, what we can and can't do for you there.
Yeah. Those were the only 2 things that you were doing.
Great.
And then I guess I think when I walk you through the information, you'll also have a better idea of how much work you'll have generally, because in particular, let me tell you this, in the documents that you get, there will be a lot of material, as you would have appreciated from the size. What you need to focus on is some affidavits which provide a narrative, and if you read they provide a narrative, but they also pinpoint the things that have been done wrong. Now, I'm not saying you take it at face value, but it'll be a good point of reference for you to understand, what all may need to be looked into. So I'm gonna identify those documents to you in an email.
Yeah.
It will be helpful if you had read them, so you have, when we speak next, so you have a point of context, and then you may also have some queries about, something that's not clear, and what I will do when I speak with you then is point to you how different files have been organized in there. There's a lot of audio recordings, there's court hearing recordings, and a lot of other things. So this is all the material, or most of it at least, that we've collected over the 2-year period. And the point of this is to sort of assist you and save your time in getting those things from different places. So if you read the affidavits, it will help you understand the lay of the land, if you will, and what different things you may need to do, and then you can ask me any questions about anything really, so I can advise you or provide you more information if you need. So I'll send.
In terms of the 5 or 6 documents that I mentioned to you,
They're all in there.
You've got all those?
All of those. So
Okay.
let me just go through the list. 1 second. So you had asked for a copy of the search warrant. That is exhibited to the affidavit. Also exhibited is the affidavit that they had used.
The applicant, okay.
We had subpoenaed that. and we have so what they've done is not given us the last page of that affidavit, which contains details about where the affidavit was affirmed, because actually it wasn't really affirmed. The two people, the deponent and the witness, were never at the same place for the period in which the affidavit was affirmed. We can prove that. So they did not give us the last page that would show that information, but the content of the affidavit has been given to us. That you'll need to subpoena. The other thing you need to subpoena definitely is the police need to do what is called a welfare check before they execute a search warrant. That tells the person who's in charge for the welfare of the police officers how they need to prepare, or whether their preparation is adequate. So it has things like information about whether it is likely that the people at the premises may have firearms, whether they have a criminal record, and so on and so forth.
Mm-hmm.
Now, they hid this information from me until literally the last day of the proceeding, and the proceeding was dismissed or withdrawn effectively because when I was cross-examining the person who was responsible for making this application to the senior sergeant, she effectively had to admit that this was there and that it hadn't been provided to me. Then she undertook to provide those documents to me and never did. She made an undertaking in court, and I was going to press for contempt of court when they basically withdrew the charges. So that's one document that you must have, because basically they have simultaneously represented to the court that I had a criminal record, whilst their internal documents showed that I didn't, obviously.
Right,
so the welfare check necessarily includes information about whether or not the person has committed any crimes, is suspected of capability for violence, or may have any weapons on them. So that document will be critical. I will give you the.
Did you say you got that already, or you never ended up getting that?
No, never ended up getting that, but I have information about the police officer who had authorized it. It's Matthew Buey. I'll send you an email about that as well, Senior Sergeant Matthew Buey, and it's in the Interpose records of the police for the investigation. So Golfs 2021 is the investigation, GOLFS hyphen 2021. So I presume you'll get all the Interpose records, definitely, from the police. And you know what Interpose is, right?
I do.
Okay, great. So when you get the Interpose records, you must look for that. It was sent through Interpose, is the testimony of the police officer who got it. So yeah, that is something I don't have. Now, search warrant I've provided to you, a receipt of any property seized, that's also exhibited to the affidavits. A document titled Result of Search. No.
Is that something that you've come across? No. There's a chance that generally the occupier doesn't get to keep it, or they won't get to keep it, but I merely asked the question in case it had changed.
No. So they basically arrested us specifically because they didn't have a search warrant, and they took us away while they went inside the premises, saw what property was there, then made the search warrant application on the basis of what they saw that day.
Yeah.
Presuming that everything in there was stolen.
Yeah, okay. So that document would still have to get filled out, but it might have been, like, there's a section on it for the occupier, but ultimately if the warrant is executed without an occupier present, it may have just been left blank, which there's nothing inherently sinister about in itself, but it was merely just to check if you had that document.
No. Well, the sinister thing was that we were jailed, so we couldn't raise questions. And it's specifically in the recording that they've arrested us, so no questions are raised. Ms. Naomi Burke, who's the officer in charge that day, she specifically points out that they don't want Lulu there because she's going to raise questions. And then the other thing is they didn't let me speak with a lawyer for 4 or 5 hours after the arrest, because, well, the official reason was that I would get the lawyer to destroy the property or the evidence, which, would have been something, given it was, large physical pieces of things and the police was there. And this is, by the way, in the notes of the police officer. He's confirmed that the officer I was speaking with, that I wanted to speak with a lawyer, and he was told that I should not because, it would affect the evidence. Under 465, they can do that if there's a suspicion that the evidence will be destroyed. And they also didn't let me speak with legal aid. So I told them that I could speak with a legal aid lawyer who perhaps would not conspire with me to destroy the evidence. But that didn't happen either. So, we didn't sign that. But the recording, the original one is there.
Yeah.
Then the enhanced version is also there. I will walk you through. The enhanced version is basically what has been done is the dead space has been removed. There's a period there of I think half an hour or a little bit more where there's virtually a dead nothing's happening basically. And we've removed that, and then we've removed a lot of we basically clipped the relevant parts. And
so that recording then, if the full recording is 4 hours, the enhanced version, the duration is obviously less than 4 hours, is that right?
Yes, so the enhanced version is in clips.
To a file that's 4 hours long, that's the original.
That's right. And then there's a folder with a lot of clips, I'd say around 40 or something clips. Those are the enhanced versions, and we've provided subtitled copies of those, so it's easier. And the only thing is that the names of the officers may be something that you need to verify in terms of who's speaking when. We've done our best to attribute statements to the right officer, but
no, that's okay.
But otherwise, yeah. So I'll wait for you to. I'll send you an email at some point before. Well, definitely by tomorrow about a couple of documents that you should look into in the folder, and I will also tell you about the Matthew Bury person about looking out for the. It's called. I forget what it's called now, but basically it's a certificate that needs to be issued authorizing the officers to execute the warrant.
I think I know what you mean. It wouldn't be a document. If it's the document that I'm sort of thinking of, I can understand if ultimately they decided not to provide it to you based on some sort of privilege. But I think I understand what you're talking about. If it's an operational document.
Yeah, but the fact that.
I understand what you're saying in terms of the relevance about contradicting the affidavit. I understand what you're getting at.
Not just that, but the person on the day who had applied for it and coordinated with the person who gave it, she had given sworn evidence that she had no involvement with the investigation apart from just faxing a search warrant application. Now, that was the other critical piece of information. This came out, so I questioned her about everything, and she wouldn't admit it. Then I literally asked her how many emails she sent that day, during the period that that she claimed she was working on my case, and to whom.
Is this the affidavit component?
This is a person who's given a statement. Yes, for the police. It's McNamara, Melanie McNamara. No, it's not the deponent of the affidavit.
Right,
It's that was Senior Sergeant Lamara Fairgrieve.
Yeah.
She didn't. So it's her testimony that she didn't know anything about the investigation, and basically other people filled out everything, and she took whatever they said at face value. And Melanie McNamara was the ground worker, and she basically played a critical role in drafting the affidavit, and also in getting the search warrant and getting the approval for the search warrant. Now, she had represented that she had no involvement in the investigation apart from just forwarding the search warrant affidavit. Officially, it was drafted by Mitchell Olney, but the problem is that Mitchell Olney was at my residence for the entire period in which the affidavit was finalized. So he's given a statement and other evidence that's been obtained through subpoena that the time that the affidavit was finalized was 1:40 or 1:20 something. He had been at my property at the time during which the affidavit was finalized. So he said he drafted the affidavit and he completed drafting the affidavit at this time. That for like 15-20 minutes before that and half an hour after that or something, he had been at my residence. Like he had jumped the fence and he was basically peeping through the glass doors in the backyard.
Yeah.
At that time. So he wasn't drafting the affidavit, and we've questioned him about that too in cross-examination. And then he basically didn't have any answer. So Melanie McNamara was the person who had done it, and she was the person who had faxed it to the courts as well. Now, when I asked her how many people she had spoken to and emailed that day, then she had to admit that she had also spoken with Matthew Bury. At which point, then I started asking her, and then it became evident that she had done more and that she had basically perjured herself. And that's when they withdrew the proceeding.
Right.
So her cross-examination was pending.
Is it the committal?
The committal, that's right. Right. So, so basically, the first day she had said one thing, and then the next day she contradicted it after she had to admit about Matthew Bury, and that's when her notes also came out. They hadn't given us the notes, and I, told the court that none of that detail was given to me, that she spoke to Matthew Bury, blah blah blah, and then she said that she had given the notes to hand over to the informant, but he, she thinks that he would have, but anyway, then she had to give me the notes right at that time, and the court required an undertaking from her that she provide the affidavit, the communication she had with Matthew Bury and the certificate he issued, and she basically did not after that. And I mean, I was brutal with the magistrate too after that, because he basically let them off without a lot of. He basically didn't enforce their undertakings and so on, and so that was pending. That I'm going to raise this with the Supreme Court for contempt, but the fact is that that's another hot area where you find the contradictions and evidence of perjury, because she has given. I'll give you the transcript as well. I've given you the audio recording of her cross-examination, the original, but I'll send you the transcripts as well and the extracted parts. But that's where she's one of the main people. Olney is obviously another one, and Burke was basically the ringleader. So yeah, okay, I'll let you go. I have to
head in a minute.
Yeah.
So what I'll do, I'll go and get that download back on my proper desk with the hardwired internet, get that going. I'll send you an email once it has finished,
Yep.
and I'll get those other questions in motion and see where I can get to by the next time we speak.
Yeah, and when you bring charges, do you bring them under both the Crimes Act and the IBAC Act, or is it only
the IBAC Act doesn't contain many offences. It gives me the power to initiate proceedings, but in terms of actual offences, it doesn't have many in it that would be relevant to this. If we're looking at crimes, the one that is front of mind for me, but not necessarily one that will shake out at the end, but the one that is generally front of mind for me in this circumstance, it's a common law offence of misconduct in public office.
It's not perversion of the course of justice?
Well, as I said, I haven't looked into this. I'm obviously at an early stage of the investigation. So whether something is perversion has, more specific elements, misconduct in public office is a more general offence. I think perversion in the course of justice was also sort of.
No, I mean perversion of the course of justice is directly applicable because it's fabrication of evidence and so on and so forth. And I think it's a more serious offence as well, right?
Yeah, it's got a higher penalty.
Yes.
What I meant to say is that I don't have to. The IBAC Act requires for me to investigate something in our corrupt conduct jurisdiction that's tied to an offence.
Yes.
But for our police conduct jurisdiction, I don't have to be tied to an offence. So I can, in this early stage investigation, I can think about different offences, be it perverting the course of justice or attempting to pervert or misconduct in public office.
Okay.
But I'm not tied into any of them in this. It's not a necessary part to get this investigation going.
No, I understand that, but what I'm trying to understand is whether at the end of this, do you intend to just publish a report, or do you actually prosecute people?
We do both. It depends on what, I guess, ultimately the evidence shows at the end, and what's there and what's not. But IBAC does have the power to lay charges. I've done it myself. I've charged people, taken them through the courts. It's perfectly open, but I certainly won't be making that decision at this early stage.
No, I wouldn't expect you to.
Yeah.
And I've gone through all the statistics that IBAC has published over the last 3 years of the cases that it's been involved in against the police, and certainly in the last 3 years I didn't see anything that involved convictions for serious offences. So this is not a usual thing, right?
We're only a small agency, and obviously I think 2/3 of our matters are from our public service jurisdiction. So I guess it's not a usual thing. That's a fair comment, but it's not unheard of.
This is once every 5 years or so thing.
In terms of
pursuing or laying charges for perversion of the course of justice against several police officers in relation to bringing proceedings and so on.
Yeah. I mean, generally, when we looking back in the past, the matters that we've charged in the police jurisdiction have been in that unlawful assault, excessive use of force space, as opposed to that higher level of professional corruption type conduct. That's just purely been our experience so far.
And I mean these idiots, they were literally passing the recording of Miss Burke, she recorded the execution of the warrant and then gave it to the current affair stalker for publication on their program a couple of days later. It was given to them next day, and
what was
the recording? She recorded the execution of the warrant on her phone and gave the video recording. And the video of them actually seizing the goods from my house was broadcast on a current affair. I mean, and then basically they wouldn't tell us for 2 years how that happened, ultimately they had to admit, and the clip was basically part of a longer recording. Then she said that she destroyed, well, she doesn't have access to the whole recording anymore. And it's only just the clip. I've included the clip. So the clip was sent by Burke to the police media team to then send to the current affair. I have the email chain through which it was sent.
Right.
And they drafted the current affairs, the script for the current affairs segment. Like what the current affair people will say. They coordinated. I mean, they were having conversations like, we should air it in this slot after the, Roger Federer coverage, so we get more eyes on it. This was a conversation between the police and the media people.
Yeah.
Like the day after.
The day after the
execution of the warrant, yes.
Right.
And by the way, just so you have your coordinates right, while they were executing the warrant, they were discussing with the current affair reporter, either directly or through the media team, what charges they should lay. So what happened is they did this whole show for me where Kuchiara showed up at my bail hearing next day. The bail hearing was not listed. So they didn't release me that night because, they didn't want to give me bail. And they basically, next day, the bail hearing was listed just that day, so there was no public record of it. He showed up at the hearing and basically pretended to take down the list of what charges were being laid, blah, blah, blah. And then basically discussed all of that. The problem was that when they discussed the charges with him on the phone the previous day, they were slightly different. And it's got on the recording.
Right.
And what he reported on his show was not what was said in court, but what they had communicated with him on the phone. So he basically went by the charges based on that. And I mean, do you understand what I'm saying?
I understand what you're saying. It's not something that I've looked into.
Well, I have. It's sections 227 and 228 of the Victoria Police Act. It's basically an indictable offence to use investigation information, and I mean it would be perversion of the course of justice anyway, because they're basically, and they destroyed the evidence, by the way. Like they took the goods and they gave them off, and even the ones that, so a small proportion of them had people saying that it was theirs, and I'll speak with you about that later, but basically all the goods predominantly were mine, and when they couldn't attribute ownership to anybody, they basically started advertising it online to say that, do you have anything missing? And when they were seizing it, they had discussed this. So the police officers under Burke were saying, what do we do? Like, we don't have any complaints about these goods. And she was like, we just basically seize everything that's not shit. And then we do a media release and say, have you had, things stolen? And people were like, we're going to get flooded with inquiries then. And she was like, well, we'll just deal with it. So that's how the whole thing was conducted. Do you know what I'm saying? Like, right at the start, she's telling people, she says, don't start taking photos until we get the search warrant officially issued, because he's going to get the metadata of the photos. She's basically mocking me for being, overly fussy about getting disclosure or whatever. And she says, and then, by the way,
that's in the recording, isn't it?
That's in the recording.
Yeah.
It's published on YouTube. And then the other thing is that, with the truck, she says, let's just seize the truck, and the informant only, he's like, what, just seize it? She says, yeah, we'll just fill it up with goods and say that it was being used in the commission of the crime. And he was like, yeah, that's an idea. And then later on, when they find that they're goods, she says, good, we don't have to fucking fill it anymore. And then basically the problem was that in order to say that the truck was seized because of that, they had to say that they had inspected what goods were inside and catalogued them. So she produced a false record of the list of goods. The truck was never unpacked or looked into until 2 or 3 days later. And she had already prepared a property record of what was inside the truck. And it was witnessed by a cop who's caught on the audio recording as saying, you can trust me. So she was like, this thing is going to be big media-wise, so I just want my close people in there. And he walks up to her and he says, you can trust me. And
yes, I do. It is 11.
yeah, sorry. Okay, all right. I'll send you the...
What you're saying there, I'll go through the documents. I'll let you know once I've got them all, and then we'll chat next week.
Okay, all right. Cheers. Take care.
Right.